Welcome to EUPrivacyForAll Session37 on GDPR, Monitoring of Approved Codes of Conduct, Article 38a. EU Council were the one proposing the drafting of Article 38a in order to create a body that would monitor compliance with the Code of Conduct and would be accredited based on 4 criteria finally retained in December in the final draft of GDPR. It also framed the way criteria for accreditation would be used and appropriate action taken in cases of infringement, the way to revoke accreditation, and the exclusion of public authorities. The final draft of Article 38a is broadly inspired by EU Council proposal. Basically, the monitoring of compliance with the Code of Conduct may be carried out by a body which has an appropriate level of expertise, this is the first condition, and would be accredited for this purpose. Being accredited is possible based on 4 criteria. First, demonstrating independence and expertise. Second, establishing procedures which allow to assess and to monitor compliance of controllers or processors to the code. Third, monitoring complaints. And fourth, demonstrating that no conflict of interest results from the tasks and duties that the body is in charge of. The competent supervisory authority shall submit the draft criteria for accreditation of a body to the EDPB. Also, the body should take appropriate action in cases of infringement of the code by a controller or a processor, including suspension or exclusion of the controller or processor from the code. In such a case, the body shall inform the competent supervisory authority. The competent supervisory authority shall also revoke the accreditation of a body if it does not meet the principles and criteria set for such an accreditation. Finally, the fact that this article does not apply to public authorities and bodies was let down. As noted in the previous session, associations or other bodies representing categories of controllers or processors are encouraged to draw up codes of conduct. The creation of a body monitoring compliance is in line with the long-run and effective implementation of accountability. Different provisions frame the action and the activity of the body in charge of monitoring compliance. It is made clear that the drafting and publishing of the criteria for accreditation of a body shall be done by supervisory authorities, as well as transparency on the way to conduct such an accreditation. EDPB, on its side, shall approve the criteria for accreditation, and infringements and administrative fines could go up to 2% of the total worldwide annual turnover of the preceding financial year if obligations of the monitoring body pursuant to Article 38a are infringed. Currently, the Article 27 of the directive does not lay down any provision regarding such a body that would monitor compliance. This requirement is part of Working Party 29 assessment, but is not once again laid down in the directive. What should accountable data controllers and processors get prepared for? They will have to monitor their compliance on the long run. They will have to anticipate that associations and other bodies representing categories of controllers and processors will draft codes of conduct that EU Commission, EDPB, Member States and DPAs will specifically check on the needs of micro, small and medium-sized enterprises, including regarding the monitoring of compliance by an accredited body. To be accredited, a body will have to demonstrate independence and expertise, establish procedures to monitor compliance to the code, establish procedures and structures to deal with complaints, and demonstrate that it carries out its tasks and duties without any conflict of interest. Such a body will take appropriate action in cases of infringement of the code, including suspension or exclusion of a controller or a processor. DPAs will have to be informed of such measures, and bodies in charge of monitoring compliance with the code will have no competence on public authorities and bodies. What will be interesting now is to follow up on concrete implementation of the criteria to be used to accredit a body and knowing more about the efficiency of such a body, notably in line with the collaboration needed with EU DPAs and the EDPB.